adjusting status in the United States versus doing consular process abroad. Which one is better for you? Which one could be more challenging? So, as always, these lives are not legal advice, education purposes only. So, you can learn about different options. What's right for you should be determined by you and your immigrant around the country you're from can totally impact. So I'm going to talk about different options, but you should discuss the actual options with your specific immigration attorneys and decide what works best for you. So we do have two different ways that people can obtain their green card when they're utilizing the EB-5 Investor Visa program. And these are not just unique to EB-5, it's pretty much any work-based green card application has two options. One is adjusting here in the United States in a lawful status in the United States status, and you have an approved or you have applied for a work-based immigration visa program. You can file for what's called an adjustment of status. So that's a request to change your status from your non-immigrant status to an immigrant category while you're in the United States. And the other way is to do consular processing, meaning that your immigrant application is first filed in the United States. After it's approved, so after USCIS says, yes, you're eligible for a green card on the basis of whatever criteria, you go and you obtain an immigrant visa at a US consulate abroad. After that immigrant visa is issued into your passport, you fly into the United States, and the day you enter the US on your immigrant visa, you become a green card holder. So two different ways. So let's dissect them. Again, as I mentioned, like adjustment of status and consular processing applies to a lot of different categories that are employment based. So whether it's EB-11, EB-2, EB-3, but specifically we're going to talk in the context of EB-5 investor visa. So I sometimes will have clients who are here in a lawful status, say they're studying in the United States, their student status is expiring, they learn about the EB-5 program and they decide, you know what, that maybe is a good path for me. My parents are going to donate the money, I will invest and apply for a permanent status. So by the time I'm done with the American university, I will get my green card and I will be able to stay and live and work here in the United States. So for people in that situation who are here in a lawful E2, F1 student status, H1B, they have this option to adjust. What that means is you pick a project, you invest in a project, and you file your initial investor petition called I-526E. And you can just file the I-526E, but if you're trying to adjust, you can file concurrently an I-526E and the 485 petition to adjust. What does filing the concurrent 485 petition do for you? It actually gives you lawful stay for the entire duration that your petition is being reviewed. So I'll give you an example. Say if my not tourist, well, it could be tourist stay, my non-immigrant lawful stay through student or tourist is going to end in 60 days. I learned about the EB-5 program today. I decide to pursue it. I file my I-56E petition and a concurrent adjustment of status. Say the average processing time for the I-526 is going to be in review for about a year. By filing the concurrent adjustment, the 485, I can remain in the United States lawfully for this year. And on top of that, when I file the 485, I can also request an work and travel authorization. So while I wait for my I-526 to be approved, I get a temporary lawful stay, and within a few months, I get a work and travel authorization. So that's the benefit. Now, in prior administrations, I would say having a concurrent adjustment of status is enough. Under this new administration, because it is a discretionary status, I would actually recommend that you maintain your non-immigrant status. So You can have a pending I-526, you can file a concurrent adjustment, but I would continue to maintain and extend your student stay or your, E2 or other stay so that you also maintain an active non-immigrant status. Because what happens is if you're not maintaining an active non-immigrant status and you're just relying on your EB-5 petition and the 485, then if the EB-5 petition is not approved, you have to depart the country, right? Because you don't have an active status. Um, where if you maintained your lawful non-immigrant status, so if you continue to be a student in an active student status and had a pending I-526 and adjustment, if the I-526 and the adjustments are not approved, you can continue to stay as a student and maybe seek other options. So this is a really important thing to touch upon with your attorneys, kind of the risk analysis of whether or not you should file a concurrent adjustment. But what are the advantages of a concurrent adjustment? For a lot of individuals, it provides a certain safety and security, especially if their non-immigrant status was going to end. So if the student status was going to end, they had no way to extend it. Having a pending adjustment does mean you're going to continue to be here lawfully. It means you're not going to have an active non-immigrant status, but you will remain here lawfully. So for some people, it buys that time to remain here lawfully while they wait for the I-526E to be approved. For some individuals, they like the idea of filing the concurrent adjustment because it does grant you or it can grant you a work and travel authorization, which usually comes in a few months after your initial filing. So it's just a way to already start living in the United States and eventually working while you wait for the EB-5 petition to be approved. Because the EB-5 petitions, depending on which project you go and depending on what year we are with USCIS, those petitions can take anywhere from 6 months to a couple of years to be reviewed. So filing a concurrent adjustment buys you presence in the United States. And it works for the investor spouse, and the children, minor children, under 21 years old. What are some of the downsides of the concurrent adjustment? Well, for one, there's going to be a window of roughly 9 months, maybe 6 to 12 months, for different people where you cannot travel abroad. So it works fine if you're someone who wants to stay in the United States, you don't need to travel out, but it doesn't work well for people who want to have the flexibility of being able to travel. Why does this period happen? Because when you file your adjustment, until you receive your temporary work and travel document, you are not supposed to leave. If you leave the United States without the work and travel document, USCIS will think that you have abandoned your 485 petition to adjust status and will cancel it. So if you are here and you filed an adjustment of status, until you receive your work and travel authorization, you basically cannot travel. So that's the downside of doing a concurrent adjustment. That's why not every single one of my clients, utilizes this option. The upside is that it does allow you to stay here lawfully. So I have clients who, maybe they came even as visitors. They came as visitors for medical treatment or because they bought an apartment in Miami and were using it as their vacation home. And after 2 months, they realized, like, wow, our kids are doing so well. They're not getting colds all the time. This is a very common story, by the way, in Florida. People come to vacation in Florida, rent or buy, vacation homes, and after a few months, they realize that their younger kids are doing really well. This especially happens for individuals who come from northern countries, where kids are always having colds and flu and, take forever to recover. And here they're enjoying a warm climate. So this is a story we frequently hear. People came for a couple of months to spend the winter and they realized they like it here. The kids are happy. Now they're looking for a lawful way to stay here. So if they discover the EB-5 program, it's the right program for them. They can file their investment and file a concurrent adjustment, which basically means they can continue to stay and start residing in the US, even while they wait for their EB-5 petition to be approved. So allows you to start living here kind of sooner. Those are the upsides. Also, when you file a concurrent adjustment specifically with EB-5, typically you also don't have an interview. So after the I-526 is approved and before your 485 adjustment is approved and your green card is sent in the mail, USCIS can call you in for an interview, but it's usually waived if you do the adjustment in the United States. Versus consular processing. So, and timing wise, an adjustment of status application is usually approved anywhere between 2 months after your I-526 is approved to 12 months. So, like usually within a year after the I-526 is approved. Now, what happens if you do consular processing? If you do consular processing, what that means is you file your I-526 petition. So you make an investment, you document that your funds were derived lawfully. Your immigration attorney puts it together in a filing, files the petition with USCIS, and USCIS adjudicates it. Takes them anywhere between 6 months and 2 years, depending on which project you're invested in, what time, what cycle, EB-5 cycle we're in. And after your I-526 is approved, you go through consular processing. That process can take anywhere between 6 years and honestly a couple of years, 6 months to a couple of years. Really depends on the consulate. There are some consulates, especially in smaller countries, where the interviews get scheduled very quickly. And there are other consulates when we're waiting for interviews for over a year. So what happens is the I-526 petition is adjudicated here in the United States. There's only one department. So I think we had interrupted. The I-526 gets adjudicated in the United States by the Investor Program office in Washington, D.C. So one office adjudicates all EB-5 petitions. So the I-526 goes there. Once your I-526 is approved, that file can automatically be rerouted to the National Visa Center. The National Visa Center is another department that processes immigrant visas for different programs. So they create a case number and they say, okay, you qualify based on EB-5, you have an approved EB-5 application. Now we need to see if you meet the general requirements for an immigrant. Send us your birth certificates, marriage certificates, your kids' birth certificates, police records. So you collect a lot of biographical documents that your immigration attorney will help you with, and you submit that to the National Visa Center. So they do this whole biographic portfolio on you and your family. They review it. It takes them usually 2 or 3 months. Once they package it, they will forward it to whichever consulate you're going to. So say you're from South Africa, or you're from London, or you're from China, they will forward it to the US consulate in your country of citizenship or your country of residence, right? Then that consulate receives this package and they say, okay, we have an immigrant visa package ready to be reviewed under this category. That consulate will look at their schedule and schedule you for an immigrant interview, depending on what their availability is. And that's so from the I-526 approval to the case being transferred to NVC, it usually takes a month or two. NVC, if you submit your documents to them right away, because NVC notifies you, they send you an email saying, we got your approval, submit the following documents, pay the following fees, fill out an online application. So you do that. So if you do that timely, typically NVC processes the package within 2 to 3 months and then sends it to the consulate abroad. How long you are going to have to wait for your interview at the consulate, that is a big question, right? Again, depends on the consulate. This is something you can go on their website and look up typical wait time. So if you go to travelstate.gov website, you can choose different consulates and see different visa interviews and the average wait time. You can also consult with attorneys who are working with those regions for them to try to see if they can get an estimated wait time. So who does consular processing work well for? Number one, it works very well for people who cannot be stationary in the United States for 9 months or more, right? So when we talk about the adjustment of status, there's going to be a period of no travel outside of the US. So if you're someone who needs to be able to travel in and out of the US or in and out internationally, say your business is based in Dubai, you want to maintain your business, your family still lives there until you get the green card, consular processing makes more sense for you. So consular processing may mean that it will take you longer to get your immigrant visa after the I-526 approval, but it also gives you that flexibility to where you can continue to reside abroad, you can continue to maintain your business abroad. If you have a valid non-immigrant visa, most of the time you can still come and visit the United States while you wait for your consular process to be completed, right? As long as the CBP understands that the nature of your visit is temporary. But typically, people with tourist visas, they can still come and visit the US as a tourist while they're going through the immigrant process and waiting for the consulate interview. So, two different processes. One, you're doing everything in the United States and you're adjusting status in the US. There's going to be at least a period of roughly 9 months or more where you cannot travel outside of the US. That's called adjustment of status. The other one, the process, you file the initial case, but you can do everything from abroad, basically. Or you can be traveling in and out of the US while this process is ongoing. So you file the initial petition with the US services, but then after the approval of that petition, you do everything through consular process. And that on average will require additional 6 to 12 months before you have your immigrant visa in hand. So with consular processes, once you are finally scheduled for the interview, you go to an interview where you're going to be asked questions about your investment, about your background. And as long as you pass the interview and the consular officer approves your case, they will keep your passport for a few days. They will issue you an immigrant visa and give you back your passports in a few days. And on that immigrant visa, it's valid for 6 months. So you have to travel and fly into the US in the next 6 months. The day you continue to not be a resident until you cross the border. The day you fly into the United States, you will be processed at the airport as a new resident. Then you go to your US home and you get a green card in the mail. Usually the green cards arrive within a month. So those are two different options, adjustment and consular process. Timelines generally tend to be a little bit longer in consular process, but I have a lot of clients doing consular process because they're still, they want to maintain their business and their lifestyle abroad until they have the security of getting the green card for sure. And once they get that immigrant visa approved, they pack up, finish up all their things that they have to do at home, where they're selling their business and real estate, and then they relocate to the United States and start living here full time. Um, those who are doing adjustment are typically people who were already in the United States on other non-immigrant visas, and they're looking to switch to a more permanent lawful status, but they're already in the US. They want to continue to remain in the US while they're going through the EB-5 process. So those are the two options. Keep in mind there's kind of like risk and rewards for both. So just run both of these options through your immigration attorneys and see which one is right for you. Um, for adjustment psychologically, we when I was a practicing immigration attorney, adjustment was a little bit better in most cases if we were handling an adjustment because any immigration process can have delay. Sometimes adjustments get approved 2 weeks after your I-526 approval. We love those years. Literally, would get a notification that the I-526 is approved. 2, 3 weeks later, we'd get the notification that the adjustment is approved, and people would have their green cards. And those are lovely times, right? And then sometimes USCIS is backed up when they re-enroll new procedures like they did under this administration, and the adjustment of status process gets delayed. It drags on for a year or maybe more. The one thing that we sort of thought was beneficial when you're doing an adjustment is if your process is delayed, you're already here. So you're waiting in the very country in which you plan to reside permanently. So your kids can go to school, you can be, once you have your work and travel authorization, you can start building your business and work and so on. Versus if your consular process gets delayed, it's a little bit more frustrating because you're waiting to start your new life and it keeps getting pushed back, right? But again, flexibility. There are individuals who run a business from abroad. They simply cannot afford not to visit their business every few months. So consular process sometimes works for those individuals. I also right now have a number of clients who don't want to relocate for 3 years. Maybe their kids are graduating high school and they want to come to the US when the kid is in college, or maybe they're wrapping up their business. So they need that extra time. At the same time, they want to have a permanent status if they're going to uproot their family and move to the US. So for those families, it's nice to be able to start their immigration process through EB-5 now while it's ongoing for the next year or two, consular process. By the time they're ready to move to the United States, they should have their immigrant visas in hand. Not part of our topic, but I always like to mention this. This is not talked enough about in our industry. If you have a green card, no matter how you got it, if you got it through EB-5 or some other way, you have a mandatory obligation for 6 months of physical presence in the United States per year. To simplify it, guys, you need to be in the US for at least 180 days out of 360 days, right? So like 183 days. If you're physically spending less time in the United States than 183 days a year, USCIS may consider that you have abandoned your permanent lawful residence and you may potentially lose your green card. Either when you go to remove conditions on your green card, USCIS is going to say you haven't met the physical presence requirement, or, if you've been absent on a longer trip when you're trying to re-enter, they may say you have not been meeting your physical presence requirement. Be mindful. Lawful permanent resident status is only issued to people who plan to live in the US. This is not one of those cards that you can have and live abroad and keep your green card for 10 years and barely ever visit the US, right? So, meet the physical presence requirement. If you cannot, for some reason, you have a big work project, your kid got into a university that they want to do a 2-year program abroad, they're not going to physically be in the US, there is a lawful way to keep your green card. You just have to get what's called a re-entry permit. A re-entry permit is a document that you apply for while you're physically in the United States, and it's a 2-year permission to basically not meet the physical presence requirement. So if you got your green card, but you realize, oh, I can't be spending 183 days in the US just yet, I need more time, file for a re-entry permit. This preserves your green card rights. So this preserves your right to your green card and allows you to be physically absent for up to 2 years. But remember, you have to file for this re-entry permit while you're physically in the United States, and you have to be fingerprinted. And once it's granted, it's like a leave of absence for up to 2 years. I hope this was helpful. I hope to see you guys next week. So we moved this session to Tuesday at 11 a.m. So hopefully it's going to be convenient for you guys to tune in on Tuesdays, 11 a.m. And send me your questions and send me your comments and questions for future lives. Thanks so much. Bye.